Good morning, everyone. My name is Mohammad Abdul Aziz, and my student ID number is 24109467. Here's my student ID card. So, the subject of my assignment is a commercial law, and the topic of my presentation is whether a buyer under a commercial sales contract is entitled to refuse to continue with the contract when the seller repeatedly fails to comply with its terms. These issues arise under the Sales Good Act 1979 and concern dispute between the Bob Decor Ltd and Wood Create Ltd. The central question is whether repeated breaches in an installment contract are sufficiently serious to justify the termination of the entire agreement. In addressing this issue, I will examine the seller contractual obligation. So, moving on the next slide. So, here is a short briefing of the summary of the transaction. A contract was signed on 10 May between two companies, Bob Decor, Wood Create. Wood Create agreed to provide 12-foot dining table, 1.5 meter long in length, and 60 wooden chairs. In addition, the quantity of chair had to be packed. The parties agreed on the delivery will be in three stages. Therefore, the quantity of each delivery should have been the same percentage of the order. So, like 10 chair each carton, they decided. Even with all these clear arrangements, first due delivery one not was agreed upon. The defected related to of the nature goods supplied, quantity goods delivered, and how part of the order was packed is uncertain. So we are talking about the commercial arrangement. Bob Decor Ltd agreed to purchase 12 oak dining tables and 60 wooden chairs from Wood Crate Ltd. The contract specified that the tables had to made from oak and measure 1.5 meters in length. It also required the chairs to be packaged in the particular way rather than delivering all the goods at once. The parties agreed that delivery would take place in three installments. Therefore, each delivery formed an important part of overall contract. So, moving on the next slide. So in this slide, we are talking about the problem with the first delivery. The first delivery contained several serious defects. The table were made from the wrong type of wood and were the wrong size. In addition, fewer chairs were supplied than required, and they agreed packaging instructions were not followed. These defects meant that the good delivered did not correspond with the contract specification. So in this slide, we will talk about the compliance with the contractual description. So one of the most important requirements under the Sales of Goods Act 1979 is that goods must correspond with their contractual description. And in this case, the contract required the supply of oak table measuring 1.5 meter in length. However, the first delivery failed to satisfy both of these requirements. The use of a different type of wood affect the quality, durability, appearance, and the value of goods. Similarly, the specific dimension of the table were an essential part of the contractual description, as the size of the furniture determines its suitability for its intent purpose. Consequently, the goods supplied did not correspond with the description agreed by the parties. Therefore, Woodcade was in breach of fundamental contractual obligation and failed to comply with the requirements of the Sale of Goods Act 1979. So in this slide, we will talk about the quantity errors. So commercial contracts depend on certainty regarding quantities. The agreement required specific quantities, exactly 10 shares per carton. However, in the first delivery, would create packed 15 shares in a carton, exceeding the agreed amount. Additionally, the seller supplied a different type of table instead of oak table specified in the contract. Both these disappearance constituted the breach of contract. By failing to deliver the correct quantity and the specific table, the seller deprived of decor of the benefit it bargained for and creates significant operational distribution. So moving on the next slide. So we will talk about the failure to follow the packaging requirements. The contract also contains specified specific delivery and packaging requirements. The parties agreed that the chairs would be packed in a boxes containing exactly 10 chairs each. As we talked in a previous slide, that as for in a first delivery, they sent 15 chairs in a carton. So this arrangement was designed to aid in storage, transport, and stock management. However, Wood Create breached this term by packaging 15 chairs in each carton, causing a logistics issue, and all thought that this breach may seem minor compared to the table and quantity error. It still represented a failure to comply with this contract. So when we talk about the second delivery, the second installment addressed some of the early issue, but still failed to meet the contract requirements. The quantity supplied in this delivery remained below the agreed amount. This pattern suggests that the problem was not the isolated mistake, but an ongoing failure in the performance by the wood grade. So when the third installment also delivered, but it did not fully resolve the previous issue. While some accepts improved, the quantity still fell short of the agreed term. Once again, this disappearance showed a recurring failure by the sailor would create. This reinforced Bob Decore lack of confidence in the sailor ability to fulfill the contract. So when we talk about has Bob accepted the goods, a sailor may argue that a buyer has accepted defective goods and therefore lost the right to reject them. However, acceptance depends on the buyer conduct after delivery. There is no evidence that Bob resold the furniture, used it in business operation, or otherwise acted as if the goods had been accepted. So the fact suggests that dissatisfaction was raised promptly. Therefore, Bob may still retain the right to reject the good and seek legal remedies. So, does the installment contract matter? So, when you talk about the fact that this is an installment contract is highly significant. With a single delivery contract, the legal analysis would be relatively straightforward. However, installment contract required the code to access all over the overall pattern of performance. The first delivery contained defects relating to the description, quantity, and packaging. The second delivery also failed to meet quantity requirements. These repeated failures suggest an ongoing inability to perform the contract properly rather than a single accidental mistake. So we are talking about the termination of the contract. The law recognizes that repeated breaches under an installment contract may justify termination if they substantially affect the entire agreement. Would create repeatedly fail to perform important contractual obligation. As a result, Bob Decor has lost confidence in the seller ability to complete the remaining installment correctly. A reasonable commercial buyer may therefore be justified in treating the contract as terminated before the final delivery becomes due. So, if the contract is terminated, Bob may also claim damages for losses caused by the breaches. The purpose of damages is to place the buyer in the position they would have been in had a contract been properly performed. This may include additionally costs incurred in obtaining replacement goods and any foreseeable commercial losses resulting from the seller failures. So we are on the conclusion. To conclude, Wood Create failed to comply with several important contractual obligations. Goods supplied did not fully match the agreed description. The quantities delivered were incorrect and the packaging requirements were not followed. These were not isolated mistakes. The breaches occurred repeatedly across successive installment and affected fundamental terms of the contract. As a result, they undermined Bob Dicker's confidence in the seller ability to perform the agreement properly. Taking all the circumstances into account, it is unlikely that Bob Dicker Ltd entitled to reject the defective goods, refuse the remaining installment, terminate the contract, so they claim damage for any loss suffered as a result would create breaches. So thank you for the listening.